You're welcome back. My guest, Dr. Kojo Pumpuni Asante, is Director Programs and Policy Engagement at Ghana Center for Democratic Development, CDD. Roxanne Nelson Eche, Dafeamapo MP, South Dai, Member, Constitutional, Legal and Parliamentary Affairs, Public Accounts Standing Orders Committee of Parliament. Seth Bokpe is Associate Editor at the Fourth Estate. And Kofi Bentel, lawyer and Senior Vice President, Imani Africa, join us. So, good morning, gentlemen. Thanks for your time. Straight to you, Seth Bokpe. Give us the highlights of what you have eventually, as it were, summarized as what needs attention for solution.
Thank you, Samson. We think that, first, let me go over the findings. So what we found is that at least 26 people who are either politicians, relatives of politicians, diplomats, or connected to our social elites had this scholarship. And I must emphasize that that is not all, because when we started serializing the full list, 6 people have been identified as the categories I mentioned earlier. And then we also found that at least 17 people received multiple scholarships, either in the same year or in consecutive years. For instance, you have a beneficiary, Matthias Abednego Bonnier, who received 807,192 cedis. That is if you convert his 81,948.46 Canadian dollars into cedis today. Now, that fee can actually cater for, when we did the value for money analysis, that fee can actually pay for 45 Master of Science in Project Management students at UPSA and 39 at KNUST. And you also found that majority of these courses that we spend money on outside are in Ghanaian universities. We also found that at least 104 of the beneficiaries are yet to return to Ghana, although they've signed bonds to do so. At least 3 of these beneficiaries have been living abroad in the last 5 years. And it will be interesting to find out how they even signed their bonds before they were given the scholarship. Now, contrary to claims that the Scholarship Secretariat provided more than 2,000, the names of more than 2,000 people to us as beneficiaries in 2019 and 2020, the number is actually 1,531. And let me give you a breakdown of it. 966 of these beneficiaries received foreign scholarships. 561 of them were for study abroad, that is the 1-year language program for French, Chinese, Spanish, and Swahili. And they had no figure attached to their names, nothing in terms of financial value attached to their names. So we could not have added them to our analysis. Somebody, for instance, was only captured as a black. I don't know how we'll be able to track this person's background. Now, we also think that the Scholarship Secretariat, as to speak now, does not have any guideline for the selection of applicants, apart from the criteria that you should be a Ghanaian and have a university admission. I think that is very basic. And then, contrary to the claim that the scholarship system, you heard the Vice President, for instance, mentioning it. Contrary to the claim that the award has been decentralized to the extent that if you go to the district level, you will get scholarship. That is for local universities. there's no evidence that those who went abroad were actually awarded at the district level. In fact, the Registrar of the Scholarship Secretariat told us that because of the cost involved, they do not award the foreign scholarship at the local level. So you have to apply in Accra. Now, how do you apply in Accra if there's no call for application? There is no publication of even the list of beneficiaries to make the process transparent. And then also, we found it interesting that when we interviewed Dr. Clement Apak, for instance, he said they are not able to hold the scholarship secretariat accountable because it is under the office of the president. I mean, when you hear the kind of allegations that come against the scholarship secretariat, including people saying they paid so much to get a scholarship, and then you have a situation where they are virtually shielded, then it becomes problematic.
There's a question that's been asked you. I think it's a lame one, though. You have received documents covering 1,531 beneficiaries of the scholarship, out of which 966 are foreign scholarships. And you have highlighted less than 30 who you say are the outliers. Why should that be sinful?
I think it is sinful because if you look at the argument had been that, oh, there's no law that regulates the scholarship secretariat. But if you marry the mandates of the scholarship secretariat from the Nkrumah days and then its own mission, which is available on its website, which reads, our mission is to utilize government funds, get fund, and other donor support for the provision of scholarship to brilliant but needy students and qualified workers at a minimum access cost for human resource development for the purpose of national growth and development, then it becomes problematic. It becomes problematic because these scholarships are going to Ghana's highest paid, Ghana's highest resource people. I mean, who are virtually competing against very poor people from Bunkurugu Yoyo, for instance. Or we're also talking about people who would not make it because they are not in a position to influence whatever decision the scholarship secretariat takes. If you have people like, for instance, Dr. Dennis Addo, the owner of Claron Hospital at East Legon, who had $50,031. In the same year, another person qualified for that scholarship and had the same Harvard, the same program, and had a little over $25,000. Then you wonder what went into the decision making.
They tell you that you cannot be making the determination about who is needy in the way you are making it. How do you respond to that? The fact that someone is he the MD of the hospital or owner of the hospital, and that
he's the founder and owner, the CEO.
Yes, give us his details again.
So Dr. Dennis Addo, founder and CEO of the Claron Hospital at Airport Residential Area, a former board member of the National Health Insurance Authority, a member of the MPP, who in fact contested the Echiman-Wabieja South MPP primaries and lost recently.
Yes, he may have money to pay for primaries, but if he's going for education and it will be of benefit to the country, they should pay for him. What's your problem?
I don't think that is a prudent use of our resources, particularly when that particular course is also available at GIMPA. And as we speak, thousands of students are stranded abroad.
He's operating a health facility. He's saving lives at East Legon, at least, is he not?
Airport Residential Area, in fact, where some of the country's deepest pockets live. I don't think it is a justification for providing a scholarship to such a person. And also, if you marry the idea, which I mentioned to you earlier, that somebody had the same scholarship in the same year, probably his classmates as we speak, would be given 25,000. What went into that decision making? And also, if you take Fauzi Ramadan, the relative of the second lady, who will pay 17,355.
You have been reminded by the scholarship secretariat that when you mention that that person is connected to the first lady, you should also mention that that person is more closely related also to the MP for, is it Adenta? Or is it?
Fair point. It doesn't.
Who is supposed to be an NDC MP?
Fair point. I mean, we are not doing political equalization. That's not the focus of our story. Neither are we targeting anybody. But a pattern emerged in the research, which we pointed out. But our concern is that in the case of this,
how could that escape you? That you are able to link this person to the first lady who doesn't bear the name Ramadan, and you are unable to link the person to the NDC MP who bears the name Ramadan. They say that's a problem with your work.
Because we found that he was a personal assistant to him.
To her or him.
Also, if we want to argue about that, I think it would be far easier for somebody who is the second lead PA to get a scholarship because of the level of influence in that office compared to an MP in the opposition party. I think that should be clear. And also, I think that we should drive home the point that the 17,355 pounds we paid for this gentleman went to waste. He didn't go to the school. He didn't attend because he said he had an accident and did not even defer the course. That is problematic. If you also have Charles Asma, who just flew by your screen, who lives in the UK, was a tax consultant and a lecturer in the university at the time he got a scholarship. He was the MPP. He currently is now actually the MPP treasurer in the UK. I mean, how do you justify that politics did not play a role in this?
You highlighted the diplomats who also received scholarships. The diplomats are serving the country, are they not? Does it matter that, they are diplomats and you think they should be able to earn enough to pay their fees on their own? And this was a colleague of mine who was also go back again, what's the name, the national, one of the institutions. Okay, so go on. So what's the point? They are diplomats. You highlight Freddie Blair's daughter, and you say the mother is a diplomat, the father is chairman of GMPC, the father has bought vehicles for all constituencies, but they are sponsoring her so she'll bring benefit to the country by studying law. And I think she's currently practicing in her private firm in Accra.
So again, Samson, we are talking about Lucy Blair, who is a managing partner of the law firm of the father, and who at the time is a qualified lawyer in Ghana. Then we are spending money to help her qualify to practice in England and Wales. And then the interesting thing, she comes back and was part of the legal team that defended Aisha Wang. Isn't that fascinating? Why do we have to pay for a lawyer, not even a state attorney, to go and qualify in England and Wales? To what benefits? How does that benefit us? I don't really get it.
Did the Freddie Blair firm defend Aisha Wang, or you wanted to refer to Efadate, who also did that job? Because that's the Efadate's son, who also you have highlighted, right?
No, I'm referring to Freddie Blair's. The firm took over at a point.
Right.
Yeah.
Okay.
And when you ask of the diplomats, the 2 diplomats we cited are the top peg, the highest level of our diplomacy. For instance, Mr. Alifo at a point acted as Ghana's High Commissioner to Canada after the exit of Ni Ayikwe Otu in 2021. You also have Florence Akuno, who got a little, I think close to about $5,000. These are not funds that she cannot have. 4,000 pounds actually. These are not monies that we will say that our topmost diplomats cannot afford and go to school. Particularly when we have a situation where we reject an applicant who needed just 4,000 cedis for UCC and couldn't get it for his master's.
Okay.
But we can afford.
Okay. Thank you for those details, Seth Bokwe. Now, there is the one that you flagged and said that the person never really went to the school, but the evidence supplied to you by the Secretariat itself shows that money in Ghana cedis in excess of, is it how much? Almost 300,000 or so had been paid to the university. What are they telling you about his situation? Are they going to recover the money or what? Because the person never went to the university.
That has not been addressed. That issue has not been addressed by the Secretariat.
Okay.
And we are hoping that going forward they will be able to speak to that matter.
All right.
And I think that at this point it will also be very important for the audit service to step in and look into the books of the Scholarship Secretariat, because there are things that I think we probably could not find because, we do not have.
So what you were giving,
audit service may have.
What you were giving was for 2019-2020, correct?
Exactly.
And you were giving a list of 1,500.
531.
Great. Now, you had been pursuing this since March of 2021.
Yes.
So, how come we are now hearing about it?
You are not hearing about it because we were given the documents in a hard copy. We asked for a PDF format, but we were giving it in a hard copy. And in fact, it took a whole year, about back and forth to get the document. At the point, when we first asked for it, they said that they needed the opinion of the AG on it because it contains private and confidential data. And then we had to go to the
private and confidential data.
Yes.
The Vice President has said from 2020 or so that everything was going to be transparent on the website.
Well, apparently it wasn't so because...
Okay, so the AG wrote and said what? They should give the information to you or you were denied?
No, after that, they did not even mind us. So we had to we wrote an internal appeal, they didn't mind us. So we eventually ended up at the Right to Information Commission. And
the commission upheld that they had to give you the information?
Exactly. But that they should redact the private data, including phone numbers, student IDs, and things like that.
And you feel it's a punishment that they decided to give it to you in the manner they did?
It was a real punishment because my colleague, who I worked with on this story, Thelma Dede America, plaudits to her, had to type this out, every single name. And then we had to cross-check again using the book to ensure that we didn't make any mistakes.
All right. In the era of digitalization and digitization, I'm sure the sector minister and the Vice President will not be excited about that. Let me begin with Kofi Bentil. Kofi, I don't get any of this. I've heard the responses that have come in and everything else, that journalists also get it, so on and so forth. So there's actually no problem. You won't share the view that picking only about 3 dozens of what you call outliers out of in excess of 1,500 names to highlight in the way that we are highlighting is not fair?
Samson, it is absolutely fair. Our job as civil society people, commentators, journalists, investigators, is not to necessarily go and look for what is regular and well done. Somehow, it falls to some of us to look for what is going wrong so it can be fixed. So the short answer is that Fourth Estate has done what a journalist must do. This is the highest form of journalism, to look for what is wrong in society, give light to it, and then hopefully work towards a resolution of it. So the short answer is that nobody should make that argument. If even there were 2 cases of abuse, this is public funds in a poor country. Those 2 cases are worthy of being highlighted, and we should go down the rabbit hole to find out how and why it happened so we can stop it. So there's a short answer, and yes, it is a very good exercise. We should also give plaudits to Fourth Estate. And you just mentioned the issue of the frustration of giving them hard copies. See, public institutions should be reprimanded for such bad behavior. You actually spend state resources to go and find the paper, buy the toner, get a staff person to print those hundreds of pages just to punish somebody. The guy who did that should be fired. These are evil people, people who do things just to make things difficult for everybody else. Okay, and it's all wrong. They make an RTI, which you and I fight for. You are dealing with public office, public funds, and you don't want to be transparent. And when the commission, the guy has had to go through the process, you disregard the law, and you are telling him that, oh, there's private information. But those people who had the private information, they were happy to take public funds and not just use it, but abuse it. And then you want to defend that. And when you lose and the commission says give it to them, you use state resources to frustrate them. My brother, some of these people should not be anywhere near public office. And those who are in charge should make sure these people don't retain their offices. They are the problem. Let me leave it here for now.
Now, I mean, Kingsley Ajiman is certainly not an evil person. He's contesting.
I'm talking about the principle.
He's contesting.
No.
Kofi Bento. He's contesting to replace Atachia in the Buakwa South.
You know what?
As the
I don't
MP,
know Mr. Ajiman. I think he's a nice person.
As the MP, he's a PhD anyway. As the MP. And guess what he did? Get what he did. He subsidized. He subsidized the cost of a bag of maize from 800 cedis to 300 cedis for the entire constituency. That's not an evil person.
People who do this should not hold public office. And Mr. Ajiman should apologize for it. Otherwise, he's not fit for the office that he's.
He says your problem is that you don't have a law regulating the secretariat, so you can now get up and want to expose facto, determine to him who a needy person is to benefit from the scholarship. That's why he's telling you that you haven't given him any law.
Should I give you my comment on that?
Yeah.
Good. Here's the comment on that. When public offices are set up, they are set up somehow with the thinking that people of sufficient competence and reasonable judgment will occupy those offices. And in the process, therefore, they would exercise their powers reasonably. If you read the article 296 in our Constitution and other places, anybody who is given powers must publish. They must publish the principles and all the rules and whatever it is by which they will exercise their discretion. The Scholarship Secretariat essentially has been given the powers of the public purse to exercise discretion in these areas. They have failed to publish it. He asking for a law is proof that he was incompetent for the job. I am not saying we should not do a law, but laws do not do everything. And we don't need laws to prescribe and make sure every rule is written. If we cannot trust that people of a certain caliber will occupy certain offices, then we are doomed. But if we make the mistake of putting people there and they come and tell us that because I don't have a law which will tell me to do this and that, I cannot do my work, that person has disqualified themselves from that office. So in short, the scholarship secretariat must publish the rules, but if the rules have not been published, people who are given these discretions are expected to exercise it as patriots with a public interest and definitely not exercise it the way they have exercised it. And when they are called to be transparent and to give information, they must not frustrate people like the journalists, like civil society organizations, like citizens who want information by doing the kinds of things that they did at the scholarship secretariat. If they do that, they have disqualified themselves, which is what I'm saying. Mr. Jima may be a fine person. Maybe if I meet him, I'll like him. But on this score, he has totally failed.
All right. I'll return to you on what should be done beyond you saying he doesn't deserve to be there, should have been fired long ago, and so on. What should be done, including his call for a legislation. And Clement Apak supports him that there should be some legislation. Now, Dr. Sant, when they mention legislation, and you refer them to at least the Get Fund legislation, through which money is set aside for the sponsorship of local tertiary education, which is very clear that it must go to gifted but needy students. They say that that is the Get Fund money that they will use for that purpose. But they have a mandate beyond that. Even though on their own website, they also underscore that the scholarship is to be given to needy but brilliant who may also be found in civil service or public service.
Well, thank you, Samson, and a very good morning to everybody. I haven't been around for a long time. So
that's right. We are happy to have you.
It's good to be here today. So first of all, let me commend the Fourth Estate for the work that they've done. I think it's triggered a very important conversation about the use of scholarships. But it's also important to commend them on advancing the scope and the development of the law and the regime around the RTI.
That's right.
I think they were cited as one of the organizations that have frequently used the RTI, and I think that's the right way to go.
Not actually one of the organization
that literally
that has used the RTI the most.
The most, yeah, exactly. And then also the RTI Commission for continue to persist with the issue of the recalcitrance of a lot of the entities that still want to be in the old order, where public information is opaque. But even in the RTI, there is a clear principle of proactive disclosure.
That's right.
And if you look at Section 3 of the Act, all entities 12 months after the coming into force of the Act are every year required to publish or update a manual which captures all the information that they want to disclose to the public. So that now I should go to the Scholarship Secretariat website. I should see a manual that says this is the information we generate on this entity. And that should even guide me to be able to know what information may be exempt and not. Of course, this has not happened, and it's something that we need to also ask the Ministry of Information what we are doing about it, and also the RTI Commission, because they are supposed to provide guidelines, around this. When I was asked to come and join the panel, I sort of spent some time just looking at scholarship schemes across the world and so on. You go to the Indian government scholarship website. Very detailed, very clear eligibility requirements, including on what is DD or what represents economic, what your income level is. Clearly stated. And sometimes I get shocked when people suggest that, somehow we are not able to determine who is needy or brilliant. When we have been doing social protection programs, even countries are categorized by, their poverty levels. We used to talk about the $1 a day, this and that. The SASCA service spends time in categorizing who is poor, who is extreme poor. Governments actually do policies, give monies based on these things. So nobody can tell me that in today's Ghana, they cannot make a distinction as to who is poor and who is needy. If there is a lack of clarity, or if there is a reinterpretation, then of course we'll get to that in terms of what we need to do to make sure that there is no confusion. But to come to the substantive matter, this is not new. And it's a very important question, observation, because when people were saying, why are people generalizing that the scholarship secretariat is being abused? We recall in 2020 when the audit service published a report, a performance audit they did on it was the GET Fund.
The GET Fund had usurped the job of the scholarship secretariat and was giving the scholarships directly.
That's right. And this covered the period 2012 to 2018, but this was published in 2020. And there, 86 beneficiaries were cited, and I think even a report to Parliament was made that some of these people did not, because the GET Fund is very clear about who is needy and who is brilliant, and that these scholarships are supposed to go for Ghanaian programs. It doesn't. And then there is this discretion that is given in 2E or so.
Section 2D emphasizes that it has to be given local scholarship.
Yes.
So you pay for the person to attend school in Ghana.
That's right.
Then the E opened a certain window.
That is where I want to really spend some time, because I think all of those listening to us, it's really important to understand that when people, there's this culture and this belief that when you are given discretionary power, you can do pretty much what you want. And just listening to Mr. Kingsley Ajimai, in his responses to the Fourth Estate, he keeps coming up with reasons why he thinks somebody will, maybe qualify. They may be twins. They may be this.
The double beneficiaries.
The double beneficiaries and so on.
He said it could be twins.
And that for me betrays a certain level of ignorance about the fetters that, even currently, where we think is not even enough, but the fetters that govern the use of discretion. And that if you are in public service and you are not aware of this, for me, it is problematic. And maybe that's where we start. But just to remind everybody, there is a clear conflict of interest injunction for all public officers under Chapter 24 of the Constitution in Article 284. So if you discharge your public duties to favor someone because they belong to your party, or you know the person, or you like their face, or whatever, in simple terms, you are denying a fair opportunity to all the Ghanaians who are eligible, whose taxpayers' money you are using to give these scholarships out. So this idea that, if I have discretion power, I can do anything. They say you cannot put your private benefit. And if me and you are in a party, and for the good of the party, or to reward party members, we get to public service, and we are handing out this as gifts. Yeah, for our private benefit, it would be great. But the Constitution is very clear that you can't use state resources for that purpose. Similarly, if you have discretionary power under Article 296, you are obliged to be fair and candid. You cannot be arbitrary. You cannot be capricious. You cannot be biased, either based on resentment, prejudice, personal dislike, and you must act in accordance with due process of law. And these provisions are very important restraints to discretion power. And if it was not for the Supreme Court decision in Ranford France, an Attorney General, Article 296C is probably even our best protection, because it said that if you were not a judicial officer, you were obliged to publish by constitutional instrument or statutory instrument how you were going to govern a discretionary power.
Guidelines.
Yeah, in terms of your guidance. And if you really think about it, and here I always, every time I meet Dr. Anyenini, I said, he is the one that has caused this problem, because he was the one that went to use the word meltdown. That if we apply this provision, it will be a meltdown. But I thought, for me, the Supreme Court got it wrong. And I thought that the idea that the Supreme Court can suspend a mandatory requirement of the Constitution, it's just a no-no. And it's something that we have to go for a review. But if you
the Supreme Court in the matter involving, I think, Brighter Kwete on the Chief Justice, oh, the title can't escape my memory this way, was very categorical.
Brighter Kwete and AG?
No, that was not the title. It was very categorical through Sophia Kufu that this injunction, that you must publish guidelines for how you exercise a discretion is mandatory.
Yes.
And actually required that the CJ will even publish some regarding how to impeach
very much so.
the head of a constitutional, independent constitutional body.
Yes.
Yeah.
So I think really for me it's due for a review, because it's really damaging. I mean, and it's interesting that in Professor Datiba's judgment, he referred to the I think the 1969 Constitution, which used the same language, and provided the justification they had made, that they had considered all the other measures and said no. But how are we going to track? How many times do people even know the number of statutory instruments that are laid before Parliament? You are not. You'll be there one day. You are transacting the business with the state and realize there's a new law that you didn't have any opportunity to participate in, whatever. But they, after looking at that, to say that, oh well, if you do this, there's a nuclear meltdown.
But for the Scholarship Secretariat, they have actually shown that this is how they will do it. And Baumia launched that and said there will be transparency. I think the problem has to do with the implementation, which is our bane in this country, isn't it?
I think it's even beyond that. And just before I even land on that point, because I also feel that even from a common law position, if you think about the doctrine of legitimate expectation, which really it has changed the way we view administrative law, that you have to be heard, you have to laws have to be predictable, you have to be fair. This kind of decision completely sort of even undermine that very But when I listen to Dr. Baumia, when I read the Scholarship Secretariat, it's very clear that the way we see the solution is in terms of access to the applications, right? It's in terms of the access to the applications, and not when even the accountability structure and how we assess fairness, how we are making judgments about what is the objective of a scholarship scheme in our context. If you read what's on the website, the general broad framework is tied to the national development plans, it's tied to particular government policy objectives, but it doesn't break it down and say, oh, we are lacking 10 engineers in nuclear science or whatever, and therefore, in this year, we want to do those things.
Yeah, thank you, Dr. Asante. Right, thank you, Dr. Asante. And Roxanne, we'll ask you to please hold on for us. We have to go quickly to the Ministry of Finance for an important development there with the IMF as they conclude their mission review. You know what we are under presently. Let's go there right away. Welcome back. This show is paid for by Bank of Africa, as strong as a group and close as a partner. MTN everywhere you go. Ashasi University, educating ethical and entrepreneur leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 years plus. My Way Insurance. Dial *165# on MTN to join My Way today. Syntax Tanks is strong, it's tough. Flamingo Paint, Simply Superior. DBS Industries Limited, Roofing, Papa Fie. And you just heard the meeting with the IMF and the finance minister, and of course, the Bank of Ghana boss, where they have concluded their review of Ghana's program that has been going on for a while now. Now, we will continue our discussion, and we have heard from Kofi Bentil. We have heard from Dr. Kojo Pumpuni Asante and Seth Bopwe. We will now hear from Roxanne Nelson Eche Kwame Dafiamapo, MP South Dai, and member Constitutional, Legal and Parliamentary Affairs, Public Accounts, Standing Orders Committees of Parliament. Like Yao Daniel Domelovo, you were also not shocked by the revelations that the Fourth Estate brought to us on this scholarship matter, or as far as you're concerned, there's nothing amiss?
Good morning, and Doc, good morning. It's been a while.
Yes,
And the show will be on until 12:30.
Okay. Good morning to my constituents in South Nine. Yes.
You never miss that.
Yes. I received some information sometime last year regarding the activities of the registrar or the executive secretary of the scholarship secretariat. And so we'll be tracking that to the extent that questions that I filed directed at the Minister of State at the Office of the President to come to Parliament to answer took so long. Eventually, when he got advertised, he failed to prepare the information for the minister to come to present to us.
And was advertised on Wednesday, the 13th of March, 2024.
Yes.
And I'm looking at paragraphs 1291 and 1292.
Yes.
Roxanne Nelson Eche Kwame Dafiamapo Sadai to ask the Minister of State at the Office of the President the details of all overpayments of stipend made to beneficiaries of government scholarships, both local and abroad, by the Registrar of the Scholarship Secretariat since he assumed office, with comprehensive account details on how the overpayments were made and recovered and through which accounts. Then there's another one standing in your name that you were to ask the Minister of State at the Office of the President the details of all official travels by the Registrar of the Scholarship Secretariat and his entourage since he assumed office, and the purpose as well as the total cost of each trip to the states.
Then that's a third one, standing in the name of the Honorable Angela Lote.
That one, Angela, Mrs. Angela Oforuwa Alote, Afajato South. She was to ask the Minister of State at the Office of the President the full details of scholarships granted to Ghanaians for both local and international courses by the Scholarship Secretariat from 2017 to date, and the quantum of stipend paid and received by the beneficiaries of the scholarships.
Yes.
Of course, there's another question by Dr. Clement Apak, also on scholarships. So there has been some interest on the part of the NDC MPs in Parliament.
Yes, because we had information.
Yes.
Okay. Now, these questions erupted as a result of the information, the sordid informations we had. One, including the fact that the Registrar of the Scholarship Secretariat travels, for instance, every week. He undertakes international travels every week.
Why, is it the GMPC boss who has been sacked, who has resigned?
Well, I don't know. And the information is that he travels large. And he travels usually first class. That is why we are asking that question in Parliament. Two, that some persons who actually applied and got the applications approved were told that you were, for instance, entitled to, say, your application, your request was up to, say, 40,000 US dollars or euros. But the approval has come for 45,000 US dollars or euros. So you should pay the 5,000 back to a syndicate. People have information on that.
You are confirming what Suleiman Isifu, the scholar in Germany, what he said on Newsfile last week, that he has seen students, he has witnessed it. It's not that he's giving hearsay information. That there's a racket, there's racketeering going on there. So you make the application, they pay money, and then you take the money when it arrives, and then you pay a portion of it to a certain agent of the secretariat.
It's like a concept.
And that one particular student, his bank account was closed because he had withdrawn more than the threshold that you could do over there.
Yes. So all these matters engaged us. The other issue is that I have been on this man for some time. My information is that he had worked in the insurance industry and he misconducted himself professionally. So the National Insurance Commission conducted a disciplinary inquiry and barred him from operating within the insurance industry. That report, I have done an RTI request twice. The NIC has refused to give me a copy of that report.
Oh, appeal to the RTI Commission. They will give it to you.
I have done that. So it was supposed to have helped me to put together a certain dossier on the man. That is why we're happy that even though we went on recess, these questions couldn't be answered. And we're hoping that upon return, we would have pursued the Minister of State at the Office of the President to come and answer. Then, boom, Manasseh releases.
And Dr. Kinsella Jiman will be listening to the show, will be watching. Please, you can call in if you have any rebuttal to the suggestions that Roxanne is making about what you may have suffered, some adverse findings against you in your earlier life. You can call us and let us know.
Yes.
Remember, last week they had a representative here, and we committed to having them back. Unfortunately, they told our production that they will be unable to participate going forward. So let's go.
Yes. So the issues at the Scholarship Secretariat is not merely because it's about Dr. Kingsley Ajimai. It's about the fact that there's an inequitable distribution of public funds. You see, we are all happy about what Get Fund is doing. Why? Because there's fairness, there's equity, there's transparency. So when you apply to Get Fund and you are a continuing undergraduate student and you have, say, a second upper CGPA 3.4 and somebody has 3.5, Get Fund will prioritize the 3.5 over you. That is fairness. That is fairness.
But the auditor found that Get Fund, by giving out scholarships, was usurping the role of the Scholarship Secretariat and had recommended that they should cease and desist.
Not at all. When that report came before Parliament, we told the Auditor General that they were wrong because the Get Fund law permits the Get Fund to do what they are doing.
It permits them to give money to the Scholarship Secretariat to disburse for scholarships for local.
We told them that there's no substantive enactment of Parliament governing the activities of the Scholarship Secretariat, and that we would prefer the statutory entity to actually account for its funds by rolling out the scholarship other than giving it to a Scholarship Secretariat that is not bound under any law. If you want to stretch it, then you may have to move them under Public Financial Management Act, which is a long stretch. Because you see, it's an extra-ministerial body set up by Nkrumah and placed under the Office of the President. And it has remained there all these years under the Office of the President. So now, when even the Auditor General audits them, they audit them under government machinery. So it's buried under litany of agencies found under the Office of the President. So the details do not come out.
Now, how do you applaud the Get Fund's disbursement?
Yes.
When the special audit,
Yes.
2012, 2017,
Yes.
or 2018,
Yes.
discovered so much rot. They had overspent by 300%. You had ministers like Opoku Prempeh, Adwoa Safo, receiving hefty sums to go for 3 weeks training in Harvard conference.
Okay, can I address that?
Money that could take care of 6 MPhil,
Yes. Can I address that? So because of that, GetFund has been directed. So they no longer do what they call the foreign heavily. They do a lot of local sponsorship, postgraduate, undergraduate. So the courses that are materially available here in several public tertiary institutions could not be sponsored in a foreign land. So they've taken the advice and stipulations from Parliament, and they are going according to. That is why when we are approving the formula, yes, when we are applying the formula, when we are approving the GetFund formula, we are able to interrogate the figures and approve of them. So as for GetFund, they are able to account, and there's transparency. But the scholarship secretariat, none. So it's such a big problem, and that is why the minority is saying that interdict the man and ask the Auditor General to conduct a special inquiry or audit into his activities between when he assumed office and when he will be interdicted. Because you see, if people conduct themselves like this in public office and there's no consequence, they consider themselves to be in a comfort zone and will perpetuate in their act. Look, Dr. Ajimai cannot say that there's no law governing what its conduct in public office. You are a public officer. You are enjoined by the LI 2378-2019, the LI underpinning the Public Financial Management Act. That whilst as a leader of the covered entity in disbursing public funds, you ought to apply certain transparent guidelines. But he won't. And he will call into programs and say that now we need the law. No. The law already exists. We may not have a law covering your entity as a scholarship secretariat, but Parliament approves funds for you. And when those funds are approved, you are enjoined under the Public Financial Management Act to apply the funds in a certain manner and account for it. You don't apply it capriciously to your whims and caprices. So my comments on this matter will be very brief. I share in the earlier submissions, and I support the call that it should be interdicted immediately for a special audit to be conducted into his activities, and then we can take it up from there thereafter.
All right. So I understand Haruna Mohammed, the MPP's Deputy General Secretary, joins us on this matter as well. Give us your brief sense of what these issues, of these issues, and then I'll get Kofi and Kojo about 2 minutes each to tell us whether we should leave this to the special prosecutor or we should go beyond special prosecutor, because the minority in Parliament have petitioned the special prosecutor to investigate the matter as brought up by the Fourth Estate. Yes, Haruna.
Thank you very much, Samson. I would say good morning to my colleagues in the studio and your cherished viewership and listeners. Having listened to all the contributions on this particular matter, I want to make some particular categorical statements with regards to what I've listened from you in terms of the 26 members that has been analyzed per what the Fourth Estate has said, that they are relatives of politicians. The 17 are multiple persons who have taken scholarships. And with regards to what the Vice President made somewhere in April 2020, he talked about the decentralization. There was a question of it not being decentralized because foreign applications are made in Accra. I want to make it very clear. Foreign applications if they are not decentralized, does not necessarily mean that they are made in Accra. Once it's online, I can make that from Zibila or from Zabuzugu or Tatale or anywhere, but the accessibility of that will be done in Accra as the evaluation processes goes through. I also disagree with the fact that relatives of politicians. Samson, you agree that every politician is a citizen of Ghana. Their relatives are citizens of Ghana. Their ability to access scholarship does not invalidate the issue of giving them scholarship to go. And also when you look at the criteria set for the scholarship secretariat, it is true, all of us will agree that there is no regulation in terms of law that governs as to who becomes a needy person. If you create an example to say somebody owns a hospital, the person is not needy, how do you define needy? There is no any constitutional rule to say that this person is needy.
The MD of a private hospital, is that what you're saying? A former board member
Yes.
of the National Health Insurance Authority?
Yes.
There's no way to tell if the person is needy or not.
There is no rule. There is no any adequate evaluation.
You want to get serious? You want to get serious? He's operating a hospital in Airport Residential?
Yeah, if he's operating a hospital, at the time he's applying, do you know whether he's needy or he's not needy? There is no any adequate qualification as to who is needy, Samson. We all agree with that fact. This is not a debatable matter. There is no adequate evaluation of a needy person because you might not know the state at which that application for chief secretariat.
Okay.
And that is what.
So you obviously are one of those who support Dr. Matthew Opoku Prempeh when he says that if the opportunity presents itself again, he would take that scholarship one more time. You support that?
Samson, for example, in 2019, I was in Ken University to do MSc project management. I applied for scholarship secretariat. I did not get. I was a deputy national communications director at that time. If it is so that politicians and high-class persons were people who were getting access to this scholarship, I should have gotten it.
The evidence we have been shown is evidence of the influential, the affluent, and politically connected who have gotten it.
But
the fact that you did not get does not negate that, correct?
But Samson, it is also a fact that whether you are political class or you are a politician or you are a relative of a politician, you are also entitled to scholarship.
Are you concerned? Let's move it this way. Are you concerned that the aide or the ones said to be affiliated to the vice president's office or so was giving a scholarship of 57,000 pounds in Ghana cedi terms today? That's almost 1 million Ghana cedis. Didn't attend, and we should not be talking about how to recover that money? You are not concerned?
Samson, I am very much concerned if there is any illegality in that process. And that is why I've always applauded Manasseh in terms of his investigative pieces. If there is any shred of criminality involved in these matters, why not? We have to investigate.
Okay, here. So here are the facts. There's no criminality. The person was awarded the scholarship. There is the evidence submitted to the Fourth Estate shows that he has been paid, that money has been paid. The person has been interviewed. He says, I did not go to the school. What do you think should be done?
The laws has to take its course.
Which of the laws? What do you think should be done?
If the person has not gone for the school and then the person took fees for a school that he has not attended, invariably the person has to refund that. And that is what we have to do. Because I am not here to defend any person's wrongdoing, but I'm here to ensure that I make the points as it is. That will be a very good representative of government. My job is to make government, the name of government image very good to the public. So if you conduct yourself in a manner that is not appropriate, then you must face the full rigors of the law, because you can't take fees that you are entitled to, but you have not used it for that particular purpose. Samson,
it's also okay. It's also okay for you. It doesn't offend your sensibilities that the daughter of your former chairman, board chairman of GMPC, who has gone through parliament, has become deputy speaker, whose wife is a diplomat, you know, the daughter got the scholarship whilst called to the bar in Ghana, got the scholarship to be called to the bar elsewhere in the UK, and then they are back in the country, and you are fighting Galamsey, and they are in their private law firms, and they are defending the Galamsey people. You are not concerned about that? A man who could afford to buy buses for each of your constituencies?
Samson, if you look at the role of the Scholarship Secretariat, one of its major work is that it has to fulfill the SDG Goal 4, and that has to look at what we call quality education. If you look at critically from the website of the Scholarship Secretariat, one of it is provision of quality education, human capital development, productivity and labor relations, and also providing manpower needs for the country. If such a person is eligible to be given an assistance to be able to support human capital development and also to contribute productivity and also providing manpower needs to the country, why not? That is done. And for your profession as a legal person, because you are lawyers, when you are defending somebody, does not impugn criminality because you are only doing your job. So if such a person decides that I'm picking up this case, or the law firm of that particular individual is picking up this case and the person is assigned to go and defend.
It's private practice. It's not practice for the state. You remember that?
It's within the remit of the person is defending what the law firm is doing, and practically the law firm.
You seriously want Ghanaians to take you serious that this is what you represent for this country as the NPP, that this is what you would defend?
No, I am not a lawyer. I am just saying that if your law firm is having a case to defend and you are part of that particular law firm and you are asked to go and defend such a case, Samson, is it going to be a bad attitude to you because you have been given scholarship?
There were people who received multiple, double scholarships. These are not evidence that they generated by themselves. It's the Scholarship Secretariat's own documents they handed to them after they were forced by the RTI Commission. Double scholarships. Somebody has scholarship the same year, doing this, doing that. And there are people who have applied in Ghana. They are looking for just 4,000 to help them. They can't get it. Some are getting 40 or whatever it is. You are okay with this?
No, I'm not okay with double scholarships. It's the same way I am not okay with double salaries that happen in Parliament. So these matters has to be properly investigated and then dealt with. And that is why I say that I always commend Manasseh Azuri on some of these particular investigative pieces.
Okay, thank you. Kofi, what should be the way forward? In 2 minutes, solutions. Should we leave it to the OSP or we should go beyond the OSP? Hello, Kofi Bento.
I can hear you.
Yes, please go ahead. Somehow I can't hear you. Please unmute.
Hello?
Yes, go ahead now.
Okay, the OSP has a role to play, but we should not leave this just to the OSP. That appointment is the political appointment. I think something quickly should be done. We should listen to the parliamentarians. These stories have been long in coming, and because sometimes you don't have the facts, you don't want to go at them, but what we are hearing is terrible. And you know, my friend who just spoke, he is making the matter worse. Some things are very straightforward. You kept asking him, you can't tell that the owner of a hospital in East Legon is not indigent, is not somebody who is a needy person, and he's going on about the, common sense of you cannot tell who is the needy person. Please, let's not do those things. I think the first thing should be the gentleman should be interdicted. He clearly, or there clearly is prima facie evidence that he has abused or misused public funds, either on himself on his travels or in terms of some of the things that have happened. And I think a proper parliamentary work has to be done to determine, one, what has happened, and two, Parliament should now say something about what should happen to the Scholarship Secretariat. I agree with some of my colleagues like Professor Prempe who are saying that more than half, if not all, of scholarship funds should be distributed among the public universities. The ones that is left, the half that is left or so, there should be clear parameters on how it will be dispersed. And Article 296, the discussion was that I didn't want to make it into a legal, but I agree with Kojo Asante that we should go back to that. Even if we don't go back to that, you remember I mentioned it in my first submission. The Scholarship Secretariat of whatever will be left of it should set up the rules on who will benefit. And it must be lopsided in favor of needy and brilliant people. Nobody should tell us that cannot be determined in this country. We've determined it in so many different ways for so many other things. It's the same argument we made when Imani was talking about doing this for free SHS, and they went ahead. Now we see the problems that we are getting when all the issues have to do with paying for boarding fees for people who otherwise could have paid for themselves.
Yes, Kojo.
I was a bit concerned when my brother Haruna was speaking, because, nobody can tell me in this country that we cannot establish who is needy. We do LEAP, school feeding. What criteria do we think we use for those things? So we shouldn't even, get into extraneous matters. I know sometimes, when you are a communicator, a political communicator, you need to, but it doesn't help.
You see how quickly he connected it to double salaries?
It's not,
because that has to do with NDC MPs.
It's not helpful.
He'll be quick to condemn it.
We don't have a lot of money. We just got a briefing from the IMF. We are in very serious circumstances. So the small, scarce resources, we have to be prudent and smart about how we use it. This idea that, every Ghanaian qualifies. How are you going to do? Even how much money are you going? If I apply for, I should get scholarship.
Every Ghanaian doesn't qualify. The Scholarship Secretariat's website doesn't say every Ghanaian. You must be a Ghanaian to start with, but you must be needy.
Thank you.
And gifted. And then they say they will also do it at a moderate cost for people in public service.
Yes, and then when sometimes you raise the issue about diplomas and things, I know outside of you in the Scholarship Secretariat, you get a lot of scholarships that are tied to particular ministries and so on, from the Japanese and others, that goes directly to people. So we need to clarify all of those processes so that there is some predictability. That's what I was referring to, that legitimate expectation around administrative processes. Okay. I also endorse the idea of a parliamentary inquiry, because this is not the first time I've heard about these allegations of bribery and racketeering that's going on. And I think when the OSP comes in, it is really to pursue the criminal matters. So it's not enough to leave it to the OSP. But one of the other things that we also have to encourage is that when the OSP comes in and then they are asking people to come and help with the investigation, then people disappear. So they are not getting, people who would have gone on social media and make statements now are unwilling to cooperate. And you cannot really move forward with investigations when these things are happening. In other places,
a senior lawyer reached out to me, and many people have reached out to me, send emails, WhatsApp messages. There are some who are talking the positives about how they came from nowhere, they made the application and they got a scholarship. And there are also others who have serious issues with the situation. So there's this gentleman who did the aptitude test and had 97 or so. The Scholarship Secretariat told us the aptitude test only forms, 20% or less.
I didn't see that on the website.
Yes. So this senior lawyer also talks about his frustrations and believes that we may be better off if we did a Chapter 23 approach.
Okay.
so that through Article 278, either the president will set up a committee or a commission, or the Council of State will trigger one, or Parliament itself by resolution will trigger one, and then we provide certain cover for the people who will testify.
Okay.
So they come to testify, yes, and they will not be in trouble when they come to testify about.
Because that has been one of the
on.
biggest issues. Many people know, but you cannot. When you cannot, the person is not prepared to come out. I've had experiences of individuals who have scored highest, whatever, very brilliant. Because at least the aptitude test is to deal with the brilliant part.
Yeah.
Right. And they will not even get, and they were told that if you don't have a political connection, you are not going to get it. And they didn't get it. So I think that if we are going to use the scholarship and treat it well, I agree.
Right.
There has to be an investigation into what is happening there.
Okay.
And where is the Minister of State in charge of this?
He says they've invited him. His questions are standing. Their questions are standing. And he's not showing up. But Roxanne, you also support the Get Fund way. Yes. But the Get Fund way was found to do a lot of bad.
It's the best of two evils. And I don't think it's...
Just like in this one, there is a name that has been published, one of the MPP communicators. And I hear the person is denying that he ever received any such scholarship. When the Get Fund one was published, I had to represent about three persons. Yeah. Their names were published as having received money 3 years ago and done scholarship.
That's right.
But they never received anything. Yeah. When we wrote, they only gave us an acknowledgement letter that they are going to investigate. As we said, nothing has happened.
Okay. Now, it's part of the racketeering. So when the Auditor General's report came before Parliament and we invited Get Fund, it was part of the reform.
Yeah,
that is why going forward, there's some sanity in that regard. So all that we are asking for is that interdict the man, let the president interdict the man. In fact, if the Minister of State had come to Parliament to answer to my questions and that of Angela, would have led to some, the matter had generated interest. Yeah. So we're just waiting for the minister to appear. Yeah. And when you ask the question, you have trade supplementary, and other members too have opportunity to ask follow-up. So it would have generated a lot of heat, and Speaker, gauging the mood of the House, would have made some consequential directives. So perhaps pursuant to Article 278, but that didn't happen. So now we have Manasseh's material. Our questions are...
This is not Manasseh's.
Okay.
The fourth estate.
The fourth estate.
Okay.
So now we still have our questions outstanding. Yes. But I'm saying that the material, the information from the fourth estate is sufficient enough to let the president's antenna go up and cajole him into making a decision that interdict the man and let Parliament look into the matter, or let Auditor General
go
into a thank you. So it is based on that forensic audit that will be able to interrogate the man.
All right, some of your messages here, and Dr. John Osai Kwapong of the CDD says that part of dealing with this issue has to be the implementation of a set of very clear prescriptive administrative rules that guide the process. I often say that the typical administrative behavior in the absence of clear prescriptive rules is this, quote, so long as the rules don't say I can't, it means I can and I should. Hashtag Vexed Matters, Newsfile. Thanks very much, Doc. We always cherish your insights here on Newsfile. I've got a good number of your messages I'm going to share with our viewers. And this one says, the Scholarship Secretariat or scheme in Ghana is nothing but fraud. In 2011, I applied for Get Fund Scholarship. I personally dropped my application at their office, then around Association School. They didn't even acknowledge receipt of the application. Meanwhile, I know people who didn't even apply but got the scholarship. We all know it, but don't talk about it. People even pay money to get the scholarship to the tune of over 100,000 cedis. Find out how the registrar even funded his PhD. Did he award scholarship to himself for his PhD? Okay, there are questions that are coming up, but I can't read that for now because he's not here to answer for himself. And that reminds me, I had mentioned that the Fauzi Ramadan had 57,000 pounds. She or he rather had 17,355 pounds. The one who got 57,000 pounds is rather the Julius Ochre, the constituency secretary of the NPP in the Ebuakwa South. Oh, that constituency where he's going to contest. Okay, where he's a candidate, where he has subsidized the price of kenke. Kojo Debris says, what do you expect from a dishonest, corrupt, unprincipled, unscrupulous, hypocritical society where nepotism, favoritism, negative lobbying, etc. are the norms of our governance system? Weep for Ghana. Kwabna Safo says, there must be some background checks on individuals filing for scholarships. And also the online platform must be free to access at all times, and also fair selection. In the Domolevo report, there were about 3,000 scholarships that were awarded. Out of the 3,000 scholarships, there was proof for only about, 12? 12. Out of the 3,000, there were about, I think, 800 that was local scholarship. And there were only 12 who submitted complete proof to meet the criteria. Yes, only 12. Siedu Francis says, if we don't change our mindset about public funds, laws will be made and infractions will be committed. And as you and I know, the mantra in Ghana, Man Friday, the most absurd part of this scholarship secretariat brouhaha is government communicators saying there's no criteria to know who is needy or not. Yeah, they have been saying that the fact that you live in London, the fact that you're already a lawyer in London and you are working as a lawyer doesn't matter. It's not a criteria to tell whether you are needy or not.
Even in London,
How then are we able to do programs for the poor? No wonder they steal state funds meant for the poor. Perez Awenam says, managing director for a prime private hospital in airport residential area is needy. Oh, yes. Kojo says, the most painful one is Freddie Blaze's daughter getting a scholarship to go qualify to be a lawyer in another country. How does that benefit Ghana? And why do I have to pay for this with my taxes? So why in God's name has the president not said a word about this shameful scholarship scandal? Well, the president may just issue a statement like he did for Cecilia Dapa, that he trusts in her integrity and that she'll be absolved at the end of the investigations. This one from Thomas Nabila, he says, we in Ghana have carved for ourselves the term needy to imply one in real need. Who do we refer to when we say needy but brilliant student? Obviously, we are referring to a brilliant student who, if not supported, may not be able to progress in education. Well, that's how simple it gets, but as you can see, it is not that simple. They say it's relative. A good office set up to help the needy has been made an extension of political party office to help political party members and their family members. Unfortunately, these needy people are the very followers of these wicked politicians, NDC MPP. I don't think we need MPP Deputy General Secretary to talk to this. Let's cut him off. Well, it's a democracy. Let's hear his views. Let's not cut him off. Let's ask him the questions. As simple as that. Okay, so I think I can pause here, even though you have a lot of your messages still coming in on the scholarship. When we return, the Chief Justice has been talking tough and revealing and sharing her vision for speedy justice, for trusted justice delivery with all of us. Within this very short time, she has managed to get as many as 12 different documents essential or guidelines essential to helping fast-track justice, and in a manner that is that will be fair and efficient. We'll return to that shortly.
I deeply crave, along with all well wishers, I'm sure, to change the tag of corruption, ineptitude, and inefficiency around the neck of the judiciary and judicial service of Ghana. We cannot do this without the support and attention of all stakeholders. The Bangalore Principles of Judicial Conduct and the Latimer House Principles are international instruments that Ghana's judiciary are committed to. In order to shake off these tags, training needs to be supplemented with consistent culture-changing strategies to deepen ethical models of work in the courts. Judicial administration must close the gaps through which court users are subjected to exploitation and rent-seeking behavior. This demands the removal of as much of the human interfacing that court work is exposed to. Court officials are expected to work with independence, with impartiality, competence, and integrity. Much of these ethical values are lost in the heavy traffic of human interfacing between court officials and court users, including unknown brokers functioning around the courts. The vision for producing culture-changing reorientation programs cannot be achieved without the active participation, the active partnership and support of stakeholders, including communities of businesses and donors.
He addressed that, look, we hear you, that you are not happy or you don't understand the process by which we choose our panels. And here is the process, or here is what I'm going to do to make sure that people have confidence in the way the panels are structured. If you just come and give kumbaya speeches on there will be no corruption and so on, people will just listen and say, oh, we've heard all of this before. We want you to have key performance indicators, specific, measurable outcomes that 2 months from now or 3 months from now or 6 months from now that we can look at and then see whether or not the things that you are saying are really happening. For instance, I would have preferred for the Chief Justice to come out and say, look, from now on, we are going to set a standard time for filing an application and completing the case. So for all land cases, from the initial filing of the application to completion of the case, the time budget is 24 months. For a family law or divorce case, the time budget is 18 months, and so on and so forth. So for all the cases that we hear in this country, litigants have a fair idea of how long the case is going to be. Obviously, in some cases, we are going to exceed the budget. In some cases, we are going to fall under the budget. But at least there's a budget. And because of the budget, we are able to know when there are variances. And then we can try to investigate the variance to know why in specific cases there have been delays.
Your leadership, whilst encouraging you for this laudable initiative, may we remind ourselves that the greatest number of complaints about the justice delivery system in Ghana border on ineptitude of judges, attitude towards litigants and lawyers, as well as delays with the conclusion of cases. I'm of the fervent belief that your vision will result in a reduction of this phenomenon. Ultimately, in my respectful view, there also needs to be a rethinking of the exercise of the jurisdiction of the Supreme Court to ensure that the workload of the Supreme Court is manageable and conducive to efficiency. Drawing on the practice and experience in other jurisdictions in and outside the common law world, the Supreme Court ought to be able to, by recourse to the enactment of regulations governing the multiplicity of jurisdictions conferred on it, and within the constraints of the Constitution, restrict the number of cases it has, especially on appeals from the Court of Appeal to the Supreme Court. This will result in the delivery of more quality justice by the highest court of the land. I say that it is a digitized environment. I say that a digitized environment results in transparency, accountability, and efficiency in the public sector, and ultimately helps to eliminate and prevent corruption. The prospect of improved productivity and reduction of costs that digitization brings requires that the judiciary embraces same fully. I have no doubt that we will achieve a fully digitized environment in the tenure of a leadership, the Chief Justice. Indeed, I see the era in which there will be the end. I see the era in which there will be the need for more virtual court houses, easily accessible to all from any part of the world, rather than physical court houses constructed in communities and accessible to only a few, much closer than anticipated.
Right, so you heard Chief Justice, Her Ladyship, Gertrude Torkornoo, and she is leading what she calls the leading justice. That's her vision, leading justice, where LEAD is an acronym for law, ethics, assets, due process, and digitalization. And she says that she received a visit from a cherished Ghanaian leader, Apostle Eric Nyameche, the chairman of the Church of Pentecost, who took her aside, and as Moses' father-in-law, Jethro, must have done when he saw Moses wearing himself out as a judge without the support of dependable partners in his leadership task. She says the esteemed apostle pointed out to me that in order to obtain extensive support beyond the cluster of help that the judiciary has used to working with, and the needed cooperation of the people of Ghana that I must serve, I should consider articulating the distinct goals within the vision shared on June 12, 2023, that's when she was sworn in, and share same with the nation with the objective of mobilizing support from as wide as a national and international base as can be obtained. And she was thankful for the apostle for that advice. And so it has led her to do the unusual. Roxanne.
Thank you. First of all, let me commend the CJ for this approach. But my difficulty is the personalization of the practice direction guidelines. Because you see, we are all trained. We know that practice directions are issued by the Supreme Court.
They have been issued by the CJ?
No, they are issued by the Supreme Court. We call the Supreme Court practice directions, not Chief Justice's practice directions. You can cross-check.
The practice directions after the Bafuboni case,
yes,
for disclosures in criminal trials
Yes.
were issued under the hand of the CJ.
They are issued in the name of the Supreme Court. Okay, so, but the attempt, because I'm saying, so are we going to cite it as CJ talk or news practice directions?
No, the directions tell you how they should be cited, each one of them. If it has to be court-connected ADR, if it has to be pre-trial for commercial cases and all, it tells you how to cite them. And
So-
the individual's name doesn't come in.
Okay, so, well, then I'm guided.
Right.
Okay, so I'm happy about the practice directions because you see, it goes to fill the small lacunas that we have in our rules of court procedural laws and all that. Then they also have a force of law. You know what I mean. So these directions will help. But you see, I am hearing the CJ speak highfalutin sounding words in terms of policy approach and all. And I'm gauging that with a conduct. I went to court. I filed a matter and followed it up with an application for interlocutory injunction. The registrar of the court, and I have another problem with that arrangement. How come we have a circuit court appointed as a registrar of the Supreme Court? How is that possible?
A circuit court judge.
Yes.
What's wrong with it?
There's everything wrong with that. Because how are you going to evaluate the work of the circuit court judge as a registrar? Because the work of a registrar...
The judicial secretary is a judge, is that not so?
She is.
Correct.
She is.
You haven't found anything wrong with that?
So I speak of approach. Because the judicial secretary, she has a constitutional role. If the judiciary decides that a trained judge should occupy that office, so be it. But the registrar of a court within the Courts Act doesn't function as a judge. So if you have a circuit court judge who is supposed to be delivering judgments at the circuit level, then she will be evaluated for purposes of elevation. Who has abandoned that?
Okay, so she doesn't leave the job as circuit court judge. So it's like acting.
Who is complaining? Who is complaining?
I am complaining.
No, but they are the ones who have employed the judicial service. Has employed the circuit court judge.
No.
Something. Why?
I think.
And if the person is capable of
It's not
playing
about
a dual role,
Is she playing a dual role? Is she sitting as a circuit judge and at the same time functioning as a registrar of the Supreme Court?
it could be secondment of sorts.
That is not
the notion.
No, that is
to
not
be
the case.
registrar.
Look, if we speak of reforms, let's speak of reforms properly. And I have a problem that we have a judge who is acting as a registrar of a court. So I filed a process. You issue a notice to me that a date will be fixed 14 days after the respondents are served with the processes. Then the next day you decide to serve a process, not on me, not on my lawyer, or my lawyer's firm. The matter is determined based on that. Then a couple of days later, you come and tell me that we want to follow procedure, we want to... So I am gauging her words with her conduct. They are not in sync.
Well,
there's
actually, in the compendium, there's actually administrative guidelines on using the Supreme Court registry.
Exactly. It is coming after what I've suffered in the court. That's the point I'm making.
That you didn't know does not mean that this had not been in place.
How is that in place?
If it were not in place, a circuit court judge would not be acting as a registrar.
But I'm saying that which law supports that?
Which law does not support that?
You can't appoint a judge as a registrar of a court. That is my point.
Okay.
Because a judge is a juristic officer. Their duties under law is separate and their privileges.
Okay, so let's not reduce it to this. Let's look at the general.
It's a very material point that the privileges of a judge who sits over cases is different from the privileges and the conditions of service of a registrar of a court. And their functions are not coterminous at all. So that confusion must be cleared. 2, I am saying that these lofty ideas are good. She speaks of budget and all. But in streamlining the judiciary, I think that one of the tasks that is hurting the judiciary It's not even about inefficiency. I haven't heard that our judges are inefficient. It is rather the workload. Having so much workload does not go to inefficiency. It's different. You can be efficient and delivering on your mandate with speed and all. But when the person who is assigning the cases is not taking into consideration the number of cases before you and keeps piling them, that cannot go to inefficiency, that cannot go to efficiency. So we should be talking about the fact that we've automated allocation of cases, at least in the High Court, in the Commercial Court, General Jurisdiction and all, those divisions. I know that the assignment of cases are automated. Under the e-justice system, I don't know, suddenly it's now digitalization, but the e-justice has been launched by government long ago under Professor Mills. In fact, when the modern court complex was built, that was when the e-justice system was launched. In fact, it had been launched much earlier, but it was piloted. But it was officially launched. So we ought to continue with that and streamline the assignment of cases to courts, that you don't overburden a judge who has so many cases or so many parties pending before him with new cases. That is why we are opening new high courts, new circuit courts, and all. That's why we are appointing new high court judges, appointing new circuit court judges, new magistrates. It is to offload the burden on the existing ones.
And also for places where there's no access.
Yes.
There are no courts.
Then
or the
I was
distance is
hoping
too-
that there would have been a report evaluating the impact of the e-justice program.
That's very important.
All right? So that we know that since the introduction of the e-justice system about 12 years ago, this has been the impact. And that when these policies are further introduced, it will help to improve the justice delivery system in A, B, C, D manner. We haven't seen that report. So when we have a court administrator for the modern...
Properly so called, the e-justice was not introduced 12 years ago.
Why?
It wasn't. It's not 12 years ago.
When was it?
12 years ago, we were doing all the manual things.
No. It was piloted.
It was
And we were in
piloted.
practice.
Where? Is it in the commercial court or the fast track high court?
It was piloted in the fast track high court.
Right.
Then it was launched by Professor Mills when in fact, he had then died.
But properly speaking, the e-justice is about, it's less than
more
5
about
years.
it's more
About 5 years or so old.
Maybe earlier.
No,
much
it's
earlier
not.
than that.
No, much earlier than that.
Oh, I
Filing
attended
of
one of the
cases.
training when we were all being trained as lawyers to know how to file your...
Including the bar took a bit of time.
Yeah.
The e-justice, when we practice, filing of process, the
Justice
scam,
Wood,
and all.
I
Yes,
remember that.
yes, the CJ Wood, she launched it.
Okay.
You know, under a World Bank facility.
Then my memory is
Yes.
just...
No, you
not
are
helping
at the
me.
bar now.
Okay.
You recall
Yeah.
those days.
So she says she deeply craves, along with all their well wishes, to change the tag of corruption, ineptitude, and inefficiency around the judiciary and judicial service of Ghana. And she says they cannot do this without the support and attention of all stakeholders.
Yes.
A number of things are being put in place.
Yes, I agree.
Including the practice directions,
Yes.
guidance,
Yes.
about 12 different ones.
Yes.
We know that they may not be binding, but you can see they are made on the basis of law, judicial decisions, and they will help to fast track the court's process, correct?
In fact, if you read Shan and Shan in the UK Supreme Court recently, it has a force of law. Because if you don't comply...
They do, right?
Yes. If you don't comply with the practice directions, a procedure pursued or a decision pursued can be struck down on grounds
Because
of
you didn't do your
non-compliance.
part.
Because, exactly.
Because the practice direction aligns with law anyway.
Exactly.
Right.
Exactly. In fact, it's like a subsidiary legislation. But these are judgment laws, so they call it judgment laws.
Right.
And they are force of law because they emanate from case law in terms of case management. These are all rooted in the doctrine of case management, which CJ correctly quoted. That is the Lancaster House principles and all. So I agree that we need to do this, but we are also gauging it with conduct. We also have a problem with empaneling the courts. Look, I have a matter before the Supreme Court, the First Lady's case. It's nearly 4 years, 2021 to now. Yeah. The issue is about paneling. One panel member is unwell, one is traveled. So now, on the 18th of March, I've been given another hearing notice to appear on the 24th. I pray that day, the judgment will be delivered. So if you have constitutional matters such as that deserves expeditious attention, and it delays this inordinately long, it's a problem.
All right.
Look at them.
So definitely you will be happy about the practice direction that is intended to ensure expeditious trials.
Of course.
Right.
Of course.
Dr. Kojo Asante, the chief critic, one of the chief critics, I should say the chief critic of our judiciary, particularly the Supreme Court, Professor Kweku Azan, when he was called, I was surprised. He was full of praise for what was going on. The online publication of judgments, all of this are part of what is going to happen. He was very excited about it, and he said even the CJ should do more of what she has begun, and she doesn't have to be personally doing it. Officers can do that for her. Before this, she held a meeting where she took questions from journalists, and she says we owe accountability to the people, so we should do it. But he then says, what I want to see is a number of things. He has issues with automation of paneling. That should happen particularly in the Supreme Court, because Justice Atuguba, he says, had complained that for a long period he was frozen. He was not being empaneled for some alleged, disagreement with a chief justice.
At that time.
At the time. He says, if you set up cases, let's know that each case will take this period to be exhausted and so on. What do you say about that?
So, for me, there are three issues around the judiciary that I think we have to address. And this could not have come at a better time, because I really think that after Georgina Wood work, Sufai Kufu did a lot, but we need a new impetus, because if there was a time where we were really worried about the judicial, the trust and public confidence in the judiciary, it's now. And every indices that you can take is showing a certain trend. That is not good. In any democracy, the whole underpinning principle, transparency, all of those things, is basically to prevent conflict in society and to mitigate. And the rule of law is key to it. So I'm happy that we are having this conversation. The issue is one of the things that I think the judiciary needs to handle very carefully, because I think that, so we have an Article 2 problem, which already overburdens the court, and we haven't managed to resolve it. Because by Article 2, you just even cannot determine how many cases. But in other places, they will say we can only do 100 this year, with some exceptions for emergency, maybe rights and other issues that are being violated. We need to look at that very carefully. But generally, because increasingly, and particularly around election matters, there's this discretion that the CJ has in empaneling. It has created a lot of perceptions around bias and independence of the court and so on and so forth. I think even sometimes there are cases that the Supreme Court should not be dealing with. These are political matters that probably need to stay in Parliament or other places. Because the more you take on these cases, anytime you make a decision, one person loses, one person.
But when they bring the cases, they must adjudicate. That's their job.
That's what I'm saying, that there are cases where the Supreme Court can say,
and decline jurisdiction.
Decline, not on the basis of law, not just on a whim, but on the basis of law. Because when you encourage, if politicians can resolve their matters, everything they are bringing it to your court, you turn the court into an extension of, and then your checks and balances become a problem.
That will not be their making.
Yeah, but it becomes...
That's what the courts are there for.
No, but what I'm saying is that we have to look at that system, both in terms of, and this is all by law, that's why I said, you have to look at the legal arrangements that you are making to limit and mitigate that problem. Because otherwise, if you look across West Africa, now every election, there is election adjudication. And it's rampant. So it's not even just the results that are being contested. In Nigeria, almost 11,000 or whatever cases that, some of them, they are still in the prelude to the actual election case. So I think that we need to look at that. We need to also look at as you're saying, time things. We have enough experience to know how much we're spending in terms of time on cases. For us to say, generally, it takes this amount of time. We can cut ABC, then as you said, we are already working on one particular aspect. So we need that budgeted time. And I think you can do that for land cases, because we have been doing it for a long time, we know. So that then you can deal with the exceptions. But it helps the public to know, if I engage a lawyer, this is really how much time, because it also deals with the access and the cost of justice. So there's a lot more detail that we need. Do we do a ballot system for the empaneling? How do you accommodate expertise? Because there are some judges who have certain expertise that you need for particular cases. There are many models around that we can adopt.
And they are shuffled so often. They may be very good in the commercial court. The next day they are thrown into a general jurisdiction court.
Even criminal court. Taken from commercial court.
Exactly. And the point is that helpful to the delivery of justice? Is that helpful to the quality of the judgments that come out? Because I've read some high court judgments and I'm completely confused. So there's a lot to be done around that. But I think for me, the trust and public confidence issue really also goes to the lower courts. And I think that's where sometimes we neglect. I spent about 6 months, some years ago, doing work on popular justice. Just anthropological, just going to the court, sitting there and observing. If you look at some of the things that goes on in the court, that is not law. So
she acknowledges that. She acknowledges
exactly.
that and talks about the staff.
Yes.
They have about 7,000 or so staff. Yeah. And there's a good number of these staff. They are not lawyers. Yes. They are just doing their work, and they need to know the law. Exactly. So that's part of the reason she calls this the leading justice. So in the lead justice, you have law. So they'll be trained on the law, so they'll know how to do.
And one of the things that I found useful those times was the disbursements of resources to these magistrates' courts were linked to certain targets and obligations, which they reported. Almost, you have to report on time. The registrar had this responsibility to report on time. And for me, it helps also in generating statistics. So there are so many, there's so many things you can use to incentivize a certain reporting and a certain alertness, to the processes that you've said, particularly the lower costs. Because sometimes when you get the perception surveys, it's really people's experiences at the lower costs that they are projecting. Because how many people come to the Supreme Court? How many people come to the Court of Appeal and other places? So those are the areas how the supervisory jurisdiction of the courts, particularly in the districts and other places. And lastly, for me, the judicial accountability component is also important. The idea of using contempt of court proceedings, I definitely don't accept judges using this to gag, speech and other things. Because, and we had a bitter experience with Dr. Anyenini because organizations like us try to mediate.
He made criticism and got into trouble.
In this space, right, where you have either the public is making commentary on something that they may not understand or don't have the knowledge about. And there is no way of sort of educating people. So organizations like us can provide platforms where you can bring academics, you can bring lawyers to try and control the conversation. And then when you do that, you get reported to the General Legal Counsel. So which lawyer can you bring to come and sit on the platform? So these things doesn't help, and we have to find
So
a way
let me go to Kofi
to
on
deal with
that.
those things as well.
Kofi, this kind of situations where, say, Professor Raymond Atuguba will do what he does as a survey, and he does what he believes is an academic work, subjects judgments to a certain analysis depending on who appointed the judge and so on and so forth, and how they made their decisions. And he is declared a persona non grata in the courts. Okay. Then you have, of course, Professor Kokwaza, and let's be frank about it. Professor Kokwaza, because he doesn't practice in our courts, he has all the liberty to say all the things he wants to say. There are lawyers who feel strongly about certain things. They will pass it through him, and you hear him advocate it very strongly. You cannot say some of the things that he says. Do you feel that now the Chief Justice is opening up in a way that will allow you to make your criticism without looking back and asking, if I go to court the next day, I'll be welcome or not?
But I hope this is the start of the opening in terms of that. I am one of the people who believes that discussing extant cases, even on air, gives better elucidation and also even helps the judges. I am one of those who believe that even if you are not, like you say, you can be fair without being, impartial. And I like it when
without being neutral, you mean, or
without
impartial?
being neutral. Sorry, the words
right.
I was looking for. I like it when I watch, for instance, Americans, discuss cases, and you have constitutional law Professor Tribe of Harvard University, retired constitutional lawyer, Justice Lutich, and very serious people discuss the case, and later you get a ruling. Let us be clear about this. The rulings of the courts, not just the Supreme Court, courts, can be discussed after the fact. The rulings of the judges can be criticized. And it is absolutely necessary for academics to be able to look at those rulings and do what Professor Atuguba did to them. Even suggest that how people are appointed as a terror has some effect. Their leanings, their previous, inclinations, and all kinds of things.
That's what you were taught in law school as American jurisprudence, right?
Yes. No, I'm coming.
I'm saying that thing you were talking about, what Professor Atuguba did. Okay. Go ahead.
Yeah. We will get to the point when we are sufficiently matured, where those things will actually be welcome. Right now, I think people are a bit too sensitive, and that is why we are going the way we are going. But let us be clear. What Professor Atuguba did is right. More of that ought to be done. Before the time runs out, let me make this case clear. I hear my brother, Dafia Meko, but please, let's be clear about this issue about the judge being a registrar. The judge is qualified to be a registrar, and nothing stops the Supreme Court from doing that. Indeed, like you said, there's another registrar who is a judge. That is number one. Number two, if the person is a judge and is a registrar, the question is whether their job as a judge is suffering or not, period. If they are performing their job as a judge well, and they are also acting as a registrar, I personally think it's a better thing than otherwise. Listen, what registrars do, even though they are not judges, has very serious judicial effects. That is procedural justice also. So for me, I was happy when that particular judge was made a registrar. The only issue is that she should not make her work as a circuit court judge suffer. Indeed, I am before her on a number of cases, and I can tell you she's a very good judge. And so far, I can't complain about her work as a circuit court judge. So let's be clear. There is no impediment in making a judge a registrar. Indeed, it is advisable.
Okay.
Provided her work as a judge.
Do you think, as some,
and I agree with the partner that,
do you think, as some suggest, that your CDD Afrobarometer 2020 had a revelation that you should not be saying what she's doing is rare, but it has become necessary? Because the Afrobarometer, Ghanaians
demonstrated lack of trust in most of the state institutions, including the presidency and the rest of them. The judiciary, 85% of Ghanaians perceived judges and magistrates as corrupt.
And I have said over and over and over again that much as perception is relevant, that particular perception, I believe, is not well informed. If you look at the volume of cases that go into our courts, and the fact that 90% plus, I believe, does not come up to any serious scrutiny. People go to court, they suffer one or two problems. I mean, I don't have time to give you examples, but I mean, they say all kinds of things. You pay the judges. I think that perception is misinformed. But that is why I believe what the Chief Justice is doing is good. Demystifying justice delivery is always good. There is too much mystery around it. So the transparency in empaneling will be useful. And I agree also, the Supreme Court is a bit too overburdened, lightening their load issue. They can issue rulings without hearing and not breach any rule. I've argued that point somewhere, that you file your processes, they can look at it, let them, write it out and let you come for it without hearing you. Now, the problems come from the lower courts. That's where the majority of the issues are.
Yes,
so
Kofi,
again,
Kofi, as a practitioner, I will not hesitate in sharing your view that it is a small number that may be the ones giving the judiciary a bad name. But does it not matter? Just as we have discussed the scholarship secretariat, the outliers matter, don't they? Take the Supreme Court, for example. When the political issues come up, public interest issues come up, the question that the judiciary and lawyers often ask is, what is the percentage of the so-called political cases that, you tend to use as the measure, or to measure whether the Supreme Court deserves the offensive, unanimous FC tag, etc. But we forget that that is exactly what needs addressing. The one small bad nut spoils the entire, handful of nuts that you put in your mouth. Is that not it?
It is, and that's where I was going. Where I was going was that the problems come from the lower courts, and the problems arise out of a lack of transparency on how the lower courts operate, and the fact that the workload is such that sometimes the judges themselves, skimp over so many things. So I was going to say, we should put more resources at the lower courts in terms of more justices, and I agree with more ADR and co. When we create that heavy duty capability at the lower courts, I believe these things will go down, especially if there's more transparency also in terms of the justice administration. All right. So I agree with what the Chief Justice is doing. What I want is for it to trickle down quickly, okay, so that there will be more capability at the lower court, more transparency at the lower court. I mean, I have been able to go to court, and the judge has heard me and vacated her ruling.
Right.
All right. Now, somebody would think it's influence. It's not influence. When you make good, arguments, it's possible.
Yeah, we have all encountered those in the courts before.
So, when people talk about judges are human.
All right. So she says that she is going to invest in technology to enhance the efficiency of court processes and administration. She intends to expand electronically access library services with support from technology and innovation teams. If you go to the Supreme Court area, I think these days they've been trying to cut some of the records away. You will see them sitting there, the whole place. We don't know how to archive them properly. She says she intends to train faculty members for online training delivery to enhance learning accessibility, establish a modern archive center for storing and digitizing court records to ensure easy retrievals. She aims for a paperless court registries to facilitate e-justice initiatives and virtual trials. Well, what I don't like about virtual trials is that I was out of the country during the vacation, and because I am not in the jurisdiction, I can't join the virtual court. The virtual court is that you must be in Ghana still. So I traveled, but I wanted to deal with the case from wherever I was, and I was not allowed. establish centrally managed transcription rooms for early processing of court proceedings to improve efficiency and cost, develop manuals to increase transparency and due process in court proceedings. Well, that 12 of them have been done so far. Provide paralegal learning materials for judicial staff and professionals to enhance understanding of legal processes. Offer online training programs with structured, pre-delivered materials and post-trained exercises to ensure effective learning, among others. Haruna is still with us. Give us a minute of your appreciation of this, and then we'll move on to the next issue. Yes, Kofi?
All these things are good, but please, she should only focus on a few and do them well. One crucial one will be transcription in court transcription. That alone, if she achieves that, so that we stop having to speak at the pace of people who are typing, that thing does violence to your...
You know the court complex system was actually built for an automatic transcription.
Yes.
Because I can, as we are talking here, I can use my phone and automatically record and transcribe what I'm saying. Why can't my court not do so?
So I'm saying here, please, Chief Justice, focus just on that. You will do massive, good to the whole system if that alone stops, and then we can do with the rest too.
All right. Deputy General Secretary of the NPP, what will you say briefly about this?
Okay, Samson, thank you very much. First, I would have to commend the Chief Justice for this particular great initiative to ensure that trust is built within the justice system. Though I'm not a lawyer, I have seen that the content and discussion around this particular matter would have been very perfect if I was a lawyer. However, justice is something that is going to strengthen the democratic process in Ghana, and all manner of processes in terms of digitalization and all the processes that the Chief Justice has to install within the justice system to ensure that there is trust, there is justice, and there is fairness in terms of delivery of justice. I believe that I am completely in support of such processes.
Great. And she started piloting the shift system also. I believe in those who say there should be rules of court or small legislation, like Professor Azan is saying, that gives timelines to everything. We did the Supreme Court presidential election petition where the rule said the trial should be expeditious. It took us 8 long months to do that, expeditious. In Kenya, they do it for 14 days. And we changed the law and we put a regimented schedule. That said 42, 45 days. And we did it under a similar thing. That will also help. Thank you very much. We'll go to the next issue. Yes, Roxanne?
Yes, 2 quick points. My brother misunderstood me. My point is that where you have a circuit court judge who is supposed to preside at a court mandatorily from 8:30 in the morning to 2 p.m., Monday to Friday, and at the same time serving as the registrar of the Supreme Court, there's no way that her work as a judge will not be affected. That is the point I'm making.
Yeah, but
so I'm saying
there will be staff she can deputize.
No, at all.
Okay.
So she's not being evaluated as a judge,
okay,
but as a registrar. And she's
so
not...
let's get to learn from the judiciary how she's evaluated before we are conclusive that she's not evaluated as...
In evaluating a circuit court judge for purposes of promotion to the High Court, they write exams, they attend interview, you submit report on cases you have done.
All right.
How is she able to do that?
Okay.
So I'm saying that approach, that arrangement is wrong.
All right. Thank you very much. Now, as you know, the NDC has been raising some red flags about some missing BVDs or biometric machines. We will find out if indeed that is what is happening. The Electoral Commission appears to say only some 5 laptops have gone missing. But the NDC insists that they are not mere laptops. They are biometric, as it were, devices that, once stolen, could be potentially used to compromise the entire election. This show, once again, is brought to you by Bank of Africa. As strong as a group and close as a partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert and Sons Optical Services, your comprehensive eye care service provider for 33 solid years. My Way Insurance, dial *165# on MTN to join My Way today. Syntex Tanks, it's strong, it's tough. Flamingo Paint, simply superior. DBS Industries, roofing. Papa Fie. Let's listen to the NDC's Director of Elections, Omani Boama, Dr. Omani Boama.
The theft at the headquarters of the Electoral Commission. And I must say, it is very disappointing, the attitude of the MPP towards this theft. Why? Because if we can have the headquarters of the Electoral Commission of Ghana under CCTV surveillance, and there is significant components of biometric verification registration kits are stolen. And listen to me carefully. The EC did not voluntarily supply the information. It was the NDC's intelligence that picked up the theft case and questioned the EC in Parliament. The question is, but for the NDC's intelligence picking this up, when would the EC have informed the political parties? And so when the agenda included this briefing on the biometric devices, we decided that we will put forward the pertinent questions, which we read all to them. I would say over 97% of the questions were not answered.
Dr. Srebo Kweku is right here in the studio. Thank you so very much for making time to join us, sir.
Thank you, my brother.
Yes. Why? If your devices are lost and somebody knows about the fact that they have gone lost and is talking about them, there should be nothing wrong about that, right?
I think it depends on what you are talking about and the authenticity of the information you are putting across.
Okay, help us understand what is happening.
So, by the way, my greetings to your viewers. The issue is that we have two types of machines that we are referring to. We have the BVR and we have the BVD. So when the NDC was saying that we have lost about 7 of the BVRs, we thought that they were talking of the BVD. We thought that they were talking of the BVRs, and they made a mistake and talked about the BVDs. Because we knew that we have lost 5 of the BVRs, not the kits per se, but the laptops.
Okay.
So we came out and corrected the impression that yes, it is true that we have lost 5 laptops in the BVRs, but not the BVDs. So that was the issue that we wanted to correct.
What do you use the BVRs for in the elections?
BVRs, the name BVR stands for Biometric Voter Registration Kits. So they are basically for registration. And it is a kit which is made up of different items. We have the laptop in it. We have the fingerprint scanner in it. We have the camera. We have the printer and the supporting tools for it. So
for registration.
For registration. So out of these components, 5 of them were picked from the kits. So we are saying that they are the BVR laptops, not the kits and not the BVDs. And something I wish that, looking at the time, we'll have enough time for me to do education. I'm here to educate Kenya to appreciate what.
That's what we have just started to do.
No,
Yeah.
those are if you have enough time. Okay, so that
yes. So what is the potential danger going into December that 5 of the BVRs, as in the laptops, have gone missing? Is there any danger?
So see, when you pick the laptop, it's like a laptop. Unless all the systems are put together before they become a kit. And when they are the kits, you need to be given activation code before you can link them to the system. And the one who is going to do the voting also have to be biometrically be empowered into the system before it could be used. So if you take the whole BVR, they have no effect because they don't have the activation code, and whoever is going to use it will not have access to link into the data system. So it's like this.
So that's a presumption that whoever takes it does not have access to the activation code to be able to access the system.
First, the laptop should be in the kit, and the kit so that it will link. Because one minute if they are in the system and you activate them, the laptop will be telling you that it has identified the camera, it has identified the printer, it has identified the camera, all the equipment that they are supposed to
scanner.
Exactly.
Okay.
So if you take the laptop, what it means is that particular kit cannot be used because there will be no linking. But if you hold it as a laptop, it is a laptop. So this laptop can be programmed, can be fit in, and it can do the same work.
But there will be useful information on it, right?
No, you see, after every registration, we do what we call end of life. In the course of doing, we will be transferring the data. But
into a certain data center.
Exactly. But we want to be sure that the system has transferred every data on it. That's what we do the end of life. So you link it up, then the system will check whether all the data in it have been transferred. And as it does so, it does the automatic deletion by itself. So once you do the end of life, every data on the system is off.
Okay. So you have not had the opportunity to use these 5 to complement the kits to be able to do the end of life.
No, we have finished.
You have done that?
We have finished. We did the last time we used the kits, some of the kits, because we have 8,500, and we used around 1,000 for the 2023. So there's 7,000 the rest were no used, right? So I will not be able to tell whether the 5 were part of the one that was used for 2023.
So there's no cause for concern at all?
Not at all.
Absolutely none?
At all. The cause we have is that Ghana has lost laptops, and it's a cost in terms of financial cost to the state. And that is why whenever we lose such things, we report to the police. You know, our place is, State Security is under National Security, complemented by the police.
That's right.
So immediately we identify that, we inform the police. And what we also want to put across is that we have routine maintenance system that we go through. And now that we are going to do the registration, we are working on the kits, preparing them for the BVDs. Within these processes, that we identify that the kit is there, but when you open, 5 of them. And immediately we ourselves suspected some of our own staff, reported them to National Security, and National Security them up now with the police. And as I speak, I know they have done it, and very soon they'll be arraigned before the court.
Okay. So you actually detected it by yourself?
Exactly.
And then you made a complaint to the police?
No, National Security.
National Security.
Right.
And now
where we are doing the servicing,
right.
National Security is the Ghana Police Service there.
Right.
But we are under the director and the National, so we inform them. Then with the collaboration of the police, they pick those people and they are doing the next investigation.
Great. Roxanne, on the back of this, this was such a false alarm that we are heading to compromise elections because some biometric BVRs are missing.
It's not a false alarm. The commission itself sent memos to their regional heads to account for machines that they were statutorily required to retire after the DLE process. Now, the regions have not been able to do so. Doctor says
that memo is dated the 10th of April 2024.
Yes.
Submission.
No.
10th April 2024. Submission of challenges in respect of the voters register used for the 2023 DLE. And this is from Deputy Chairman Operations to Regional Directors. And it's copied to Chairperson, Deputy Chairperson, Corporate Services, and they're asking all of them at a certain time to submit the challenges that they face in respect of
that is different.
He's talking on the BVDs.
Okay. Right.
Now,
there's another letter. I'll look for it.
There's another memo. I think it was a February memo.
Okay.
February.
Go ahead.
Now, doctor says that because the laptops have been taken out of the kids' box, so to speak.
Please, let's differentiate the two. I was referring to BVR kits.
BVR kits.
But the memo you're talking is about the BVDs.
Right.
So if you want me to explain that one too.
Okay.
Do that.
Yes, the BVDs. Why did you ask your...
So what is happening that the BVDs are for their
phone like this, a tablet, yeah.
So the BVR is a laptop. But this time we are talking of the BVD, biometric verification device. That is used in the course of voting for you to be identified. So there are two different issues. Now, we have 74,000 plus. So we sent them to the fund. The commission has robust tracking system. So when they brought them, our procurement inventory department, where we used to call them stores, they identified that these ones have not been brought. I think they're about 28 or so. So the deputy chair wrote to them that by the checks and what they brought, these ones have not been brought. Now, they decided responding. If you take Nanton, for instance, what happened was that, as you speak, there was an issue, so that election has not been heard. So the 7 BD that were sent to that electoral are with the police in the northern region. So this response will come. So those who have issues with them, sitting here, what I can say on authority is that we lost one BVD in North Town, and what happened was that they normally package all this in the ballot boxes. You put your systems and you seal. In the course of transporting, you go there, they couldn't trace the ballot box. So we report to the police, and as of now, we haven't seen that.
So there's only one
that is what we
BVD lost.
That North Town.
Okay.
Then lost has different definition.
Okay.
Then in Takwa, 5 of the BVDs were destroyed. In the course of collision, the electorate has 5 polling stations. So they were like we are sitting here with the police and the rest. The people stormed there, everybody ran for his life. They took machines and destroyed, including the ballot boxes, the screens and the rest. So this one were vandalized. But this one, they took it, so it was not destroyed, but they took it.
In both situations, BVDs and BVRs, in both situations, there's no cause for alarm.
At all. So with respect to the BVD, it is like the phone that I'm holding. So when we are ready for an exercise, then we capture, if it is for general election, then we do it constituency based. So we transfer the constituency voters onto an SD card.
Like what is happening in Ajuso today, you will not be using that. Using their own...
Exactly. So we just insert the SD cards onto the BVD. Then we will send them through the region to the district.
Okay.
The district to the polling stations. Then the IT people will give them activation code at the dawn of the election. So it is when they activate that the system becomes active for usage.
Okay.
So till they are activated, it has nothing to do. And when they are activated, it is only used by capturing the QR codes. So as we speak, we have no generated register for 2024. Therefore, we don't have QR code for 2024 registers. Therefore, if you are holding it, you cannot use it. Again, you will not have the code, because activation code, I have never heard it before, because I don't use it. It is those who are going to use it who are given the activation code to use. So if you hold the...
So there's a potential of a breach. You don't rule out.
Not at all. Because if it is going to be a breach, then it is the IT people who generate the code who will give the code to the one who has whatever.
That's what I'm saying.
So when they do that, what will be the usage?
Okay.
Because you need to have a register. I mean, hard copy register before you can use it. So what it means is that you have the same polling station, you have the one given to you illegally, and now have maybe the legitimate one. So when we do the verification, you assuming that you are going to be given ballot papers.
Right.
So if you do, that's what it means. You need the activation code. You need to be given a hard copy of the register. You need to be given ballot papers before you can use it to vote. So at the end of the day, it is not possible.
Okay.
That is like
we don't have time, but now, very quick one. Your officers who were involved in the BVRs that have gone missing, why did you hand them to security and to police?
No, it's like over here. If somebody steals, what do?
You consider it to be stealing?
Yes. So that's why we said that we have laws this and these are the suspects. So investigate and let them go through the legal regime, whatever has to be done, should be done. So they have been interdicted. They are now going through the security investigation. So the police, I'm told that they will be arraigned before court soon.
They'll be arraigned before court.
Yes, because it's being treated as a criminal case. If they are found guilty, the law should deal with them.
Okay. So, at a point I was thinking, but they are working, and at the workplace, things can happen. People lose things. So why would you, want to treat them that way? But if that's the way you want to treat them.
We suspect that they are involved.
Okay.
So the investigation will establish whether we have prima facie case or whatever.
That's right.
So that the court will handle that. So we will not come in because we're talking about state property.
The most important thing here and take away for me at this juncture is that regardless of the BVDs that were vandalized and the one that is missing, regardless of the BVRs that have also gone missing and people are being dealt with as a matter of theft, there will be no implication whatsoever negative for the 2024 elections in December. Dr. Omanibuama is Director of Elections of the NDC. He joins us here right now. Why have you put us into panic?
Thanks very much, Samson, for indulging me. I had to move right from a funeral right to this place because I heard Dr. Srebo Kweku trying to explain, and if listeners do not really know the background to this, they are likely to be swayed. I want you to ask Dr. Srebo Kweku right now, when did the theft take place at the EC headquarters?
Why does that matter?
It matters. When?
Okay. When did this happen?
So like I said, we are preparing the BV.
This is a simple question.
Oh, yes. So that's when we started. I think I started it.
Yes, you are doing end of life.
No. When we started preparing them for the registration, it in the course of that, when you opened the read that 5 of them were not there.
Okay.
When?
Oh, we started about a month ago.
So it was just a month ago.
Yes, about a month ago. And immediately we detected it. We knew who are those who are supposed to be handling that. They've handed them over to the national security.
Okay. When were the people arrested?
Immediately we gave the information to the national security. They picked them up. So you can check from them. They picked them up.
No. So they were arrested because you should know. So they were arrested about a month ago.
Yes, I think.
Very good. Please, I'll call for this recording because as we investigate this matter, we will get to know when the theft I took.
Let's hear your contrary knowledge. What is it?
I do. It is more than a month ago. The second.
Now, which one? Is it the detention or the reporting of people to the
theft? The theft.
It's more than a month ago. Yes. When?
More than a month ago. Way more than a month ago. That's one. 2, has the EC reviewed the CCTV footage? No. I mean, if even in our homes, if
you said the time they got missing or got stolen was important.
Yes.
So I want to know what's the impact of the time. If they go missing more than a month ago, what changes?
Very good. I want to use that to let you know that but for our intel, this matter would not have been out there. That is one. Two.
Would not have been reported or would not have been out there.
Would not have been out there. Two, the EC has not demonstrated enough commitment towards ensuring that key stakeholders know the fullest extent of this. And this is why we will not trust the Electoral Commission of Ghana when they decide to give assurances based on nothing, that everything is intact. We shouldn't worry. Because what we are discussing today is demand-driven. But for our MPs in Parliament, putting a question to the EC in Parliament, the EC was never going to inform either Parliament or the political parties that this occurrence had taken place. I then move on to...
They deemed it inconsequential. Why should they be announcing to the world about this?
Since that's 96, we have been losing the immediately happy. We report to the police.
They deemed
when we don't come and inform the political party.
They deemed it inconsequential.
Sorry, our time is just up.
I know, and that's why I'm very happy that you're giving me the opportunity. They deemed it inconsequential that not mere laptops. And you see, the EC's attempt, and I'll say it bluntly, to lie to the good people of Ghana that even though BVDs were missing, itself was also disingenuous. When in actual fact, at IPAC, it became obvious that even some BVDs are also missing. It tells us that so long as they can use BVD to confuse the uninitiated, and they succeeded in doing that, we tried to let people understand the distinction between the two. They were okay, I with it. Samson, we will file an RTI on this.
All right.
We will also send the questions officially one more time to the EC.
Okay.
And we will push to the farthest extent, as our national chairman has indicated, an independent audit of the EC's IT system will be non-negotiable. Vain assurances from the Electoral Commission of Ghana will not cut it for the NDC.
All right. Thank you very much. Our time is up. We've actually run out of time and we're being cut off if we spend the next minute again. My guests have been Dr. Sribo Kweku, who is Director, Electoral Services at the Electoral Commission, Dr. Kojo Pumpuni Asante, Director, Programs and Policy Engagement at the Ghana Center for Democratic Development, Kofi Bentil and Haruna and Doc. We hope you understand why we had to focus on Dr. Kweku and Omane Boama for now. And also Nelson Eche Kwame Dafiamapo MP, Saldai, Member, Constitution, Legal and Parliamentary Affairs, Public Accounts Committee, Standing Orders Committee of Parliament. Dr. Omane Boama also just joined us, and it does appear that we may need some more time subsequently to interrogate this matter further. I'm Samson Lardy Anyenini. As always these days, my outfit is by Konati Clothing. Have a good afternoon.